Ladies and gentlemen, welcome to today's webinar. It's good that you have joined us today. My name is Elizabeth Njoke, and this webinar is brought to you by Njogu and Associates Advocates. And one of our specializations is data protection. If you have been following us, you might be aware that we have been last year we did a couple of webinars on data protection. So it's been a series that we've been running. We want to pick up that conversation on data, and this comes especially after a recent directive by the Kenya Medical Practitioners and Dentists Council, where all health institutions are now required to register as data handlers. So yeah, they're required to be registered as either data processors or data controllers or both. And so that's what forms the basis of our discussion today. So my colleague is the one who will take us through, will be taking us through the discussion, and I'm going to allow her to take it up from here. Welcome, and I hope you have a good session.
Good afternoon, everyone. My name is Victoria Wainaina, and you've been welcome to this meeting. So we'll proceed right into the heart of it. So today we're dealing with data protection in healthcare. Give me a minute to share my screen. So for today, our outline, we'll start with introduction. Then we look at the regulatory framework, and then patient rights and consent. Then we look at data processors and controllers. We look at their obligations and how best to ensure compliance. We'll then delve into case law and then propose best practices for compliance. And then we can conclude. The healthcare sector is in a profound transformation at the moment because we are looking into spaces where we're exploring AI for our health sector. And also these innovations, they have numerous benefits, such as patient care and advanced medical benefits. But then it presents significant challenges in the sector of safeguarding health data. So with that, it brings about the issues of cybersecurity because when personal data or health data is not properly stored or safeguarded, it can result in issues of fraud, identity theft, loss of trust from patients, collapse of organizations, because you can be given hefty fines that require you to close shop. So we'll begin with the key concepts. So the major words that we'll be using here will be personal data, which means information that relates to an identified or identifiable natural person. And then since this is about healthcare, we'll be looking at health data, which relates to the state of physical or mental health of data subjects, including records of their past, their present, or future state of health. We'll also be looking at sensitive personal data. Basically, this is a classification of personal data that is considered sensitive. These are issues of people's race, their health, their ethnicity, their social origin, conscience, belief, genetic data, biometric data, about property, their marital status, sexual orientation, etc., etc. And so for the regulatory framework for data protection in Kenya, we start with the Constitution of Kenya 2010, Article 31, D and E. They're the ones that give health to the Data Protection Act, because Data Protection Act is made pursuant to the right to privacy. So we also have the Health Act of 2017, the Digital Health Act of 2023, the Data Protection General Regulations of 2021, the Data Protection Registration of Data Controllers and Data Processors Regulations of 2021, and guidance notes that have been given as guidance for the regulations and also for the Act itself. And so we look at the Digital Health Act, because mostly for the processing of personal data concerning us moving into the digital space, it became a necessity. It is a very recent act. It's a 2023 act. It regulates the use and implementation of digital health data technologies in Kenya. So it aims to establish a framework for integration of all digital tools in healthcare. And it defines digital health as the field of knowledge and practice that is associated with the development and use of technologies to improve health. So while implementing this act, there are guiding principles for the act. And among the guiding principles, it states that health data is a strategic national asset. So it's also mandated to ensure that privacy is safeguarded, confidentiality, and security of health data, and how also the information is shared or disseminated. So key aspects of the Digital Health Act concern the regulation and oversight. This is basically the overall overseeing of how these digital health tools are applied, the platforms, the services, the MyDawa platforms, the use of AI also. And so it also deals with health data management. How is this data collected? How is it processed? How is it stored? How is it shared? And at the end of the day, how is it destroyed? So it also looks into issues of the processing of this data while ensuring privacy and also confidentiality. Because as we are aware, health data is very sensitive information regarding individuals. And also, it also provides for the integration of digital health solutions, and it also gives for capacity building to promote training and capacity building for healthcare professionals or healthcare workers. So we delve into the patient's rights and also the issue of consent. So the following are the rights of patients. In this case, we're saying patients because they are our data subjects when it comes to the healthcare sector. So the patient has the right to be informed of the use for which their personal data is to be put to use. So you must inform these people, am I collecting your health data? Is it for research? Is it for your diagnosis, or is it for whichever other reason? Then they have the right to access their personal data in the custody of a data controller or a data processor. This means that should a patient visit a healthcare facility where they're being treated, they have the right to access the medical notes from their doctors regarding their diagnosis, because that is their personal information. There's also the right to correct any false or misleading data, and also the right to deletion of false or misleading data about them. So you can correct or you can delete. The choice is on the data subject. They have the right to do either of those. They also have the right to object to the processing of their personal data. But there's a caveat for this. Yes, you can object, but this right may be overridden where the data controller or the data processor demonstrates that there's a compelling legitimate interest for them to process this data, which overrides your own rights. This is in cases of either defense of a legal claim, or in issues such as during COVID-19, where they needed to do a study so as to project any other future issues. And then a healthcare provider must ensure that they obtained consent. The consent must be direct. You cannot say that this person, by doing ABCD, that they have given their consent. When you look at the definition of consent in the Data Protection Act, it says that the consent has to be direct and unequivocal. And by unequivocal, it means it has been put out in very clear words that I am giving you consent to process my personal data, specifically this health data, for A, B, C, and D uses, whether it's for the diagnosis, whether it's for research purposes, or whether it's for the medical tests. So the exemption is where the health service is provided according to public health requirements, either according to the Public Health Act and in compliance with any other requirements. And when processing this data, the healthcare provider, who in our case may be the data processor or the data controller, must ensure that this information is kept confidential, and they must provide the prompt and accurate data necessary for the treatment of this patient, and they must comply with the duty to notify the data subject in case of any breach. And also the data subject, which in our case might be a patient, they have the right to withdraw this consent at any point by notifying the healthcare provider that they no longer wished for their personal information to be processed. So we look into medical consent vis-a-vis data protection consent. So as we have said, consent must be clear, direct, and unequivocal. So for medical consent, it's the consent that is usually required when patients are undergoing medical treatment, surgery, or participating in clinical research. So it is focused on ensuring that this patient understands the nature of the medical procedure, the risks, the benefits, the alternatives they have, so as to enable them to make an informed decision about their health care. So the focus here is on bodily autonomy. This is my body, so I am being given, I can do A, B, C, and D. These are the risks, these are the benefits. Instead of A, I can go with B, and here are the reasons. So for the data protection consent, it's more of consent relating to the processing, to the collection, the processing, and the storage. This is the whole data cycle where the information is collected, it is then processed, it is then stored, and then it is then deleted or erased. So under the Data Protection Act, individuals, you have the right to know why the data is being used, where it is being stored, and in case of sharing, who is it being shared with. And the focus here is on self-determination, the right to have control over how much information about the person is disseminated out there to third parties. So while these consents, both of them, the medical consent and the data protection consent, they require informed and explicit permission. The distinction is in what they govern and in what they protect. For medical consent, it's more of bodily autonomy. Well, for data protection consent, it's about information, self-determination on who has the right to access my personal data. And then for the medical bit of it, it's about the bodily autonomy. What do I do with my body? Do I undergo this procedure or not? What are the risks involved? What are the benefits of this? Can I sit it out? Yes, so that such information allows you to make an informed decision about your body. So we come to the genesis of today's webinar, which was this notice to health facilities, requiring them that for all data handlers and processors to obtain certifications. So the same said that for new facilities, beginning January 2025, they are required during registration to obtain the certification. And for existing healthcare facilities, they have until the 31st of March 2025 to comply with the same. So in the next part of this session, we'll be talking about who exactly are these data handlers, who are the data processors, and what is this certification about, what is required when someone is certified as a data processor or a data handler. So for the data controller, a data controller it can be a natural or a legal person. In this sense, it means it can be an individual, a human being, or an entity such as a partnership, these legal bodies that are created by statute, not necessarily human beings, companies, yeah, etc. So for a data controller, it is a person who determines the purpose and means of processing personal data. Like they may either do this by themselves or as a team or as a group. And for a data processor, they process data on behalf of the data controller. So the data controller is up here, and then the data processor is up here. And there's a very thin line for the data controller and a data processor. Because if a data processor processes personal data on behalf of a data controller, if they process data that is not within the scope of what they were told to process by the data controller, then they become data controllers, because they are the people who have determined their own purpose and the means of collecting the personal data. So they are no longer under the umbrella of a processor, but their autonomy in doing things outside the scope of their instructions by the data controller makes them a data processor. And the following are the responsibilities of data controllers. And these, the responsibilities are synonymous to the principles of data processing. These are the principles that data processors and data controllers must adhere to when processing personal data. And the first one is privacy, because that is the backbone of the Data Protection Act of 2019, which is provided for by Article 31 of the Constitution of Kenya. So it must be processed, personal data must be processed in a manner that respects the data subject's right to privacy. So it must also be transparent and ensure that the same is lawful and it is fair. And when collecting personal data, the data processor or the data controller should only use the data for exactly what it was collected for. And this use must be clear, and it must be a legitimate purpose, and do not process more than is required or or anything that is incompatible with the purpose of the collection. If you had used the data, if you had collected the data, well, let's say with the purpose of conducting clinical trials, the same cannot be used as if it was only allowed for clinical trials, then you cannot attempt to treat this patient with the same, because when you are collecting this data, they were very specific. You can use this for the clinical trials, but do not use it for research, etc. So for whatever purpose it is stated for, use it for exactly that purpose and not for any other purpose. And then data minimization. You only collect what is relevant, what is adequate, and what is limited to what you need it for. We will see some case law explaining exactly the concept of data minimization, which relates to just collect exactly what is enough, not more. And then for data accuracy, the data should be accurate, it should be kept to date, and steps should be taken to rectify or delete. This is in tandem with the data subject's right to rectification of their data, and also their right to erasure of the same. And also there's also the principle of storage limitation. When you collect personal data, you only keep it for the time that it is necessary to complete the purpose for which you collected it for in the first place. And Section 25 of the Digital Health Act, it states that data held in the system may be maintained for a minimum of 20 years. But there are exceptions to this, where it is shown that it is for a legitimate reason, or it is required and allowed to keep this data for public health reasons or for national health and security. Yeah, and also for international transfers, data should not be transferred out of Kenya unless there are adequate measures and also consent from the data subject, so that you know if the data processor or data controller intends to transfer your data outside Kenya, they must meet thresholds showing that this is the level of security that we have put in place, that this data gets to whatever destination it was meant to, without infringing on the rights of the data subject. And then when collecting personal data, it has to be direct. You collect it directly from the data subject, but there are also exceptions to the general rule. So there are circumstances where collection is allowed, like from public records with consent, or when it is necessary for law enforcement. And also, the data can only be collected for a lawful purpose. You collect it, you store it, and you use it only for the purpose it was collected for. And the purpose that it is collected for must be a lawful purpose. And there's also the requirement of notification of data collection. This is provided for by the guidance notes on the procedures on health data. So to ensure transparency, institutions must provide either data policies or privacy notices. And such a notice must include relevant details about the processing activities. So you must say which category of data is being processed, the purpose for which it will be used, how it will be collected, how it will be kept up to date to ensure it is accurate, and how it will be disposed of, and also details on the use of security systems such as computer passwords. Are these things effective? And also, where necessary, how the data will be encrypted when being held electronically so that it is not leaked to other third parties that are not allowed to have access to the same. And then it must specifically say who is considered a trusted third party. And if it is a trusted third party, this means that they have access to such data. And they must also give procedures on what will be done in case personal data is lost or stolen. And also when sharing or transferring that data outside the specific healthcare institution, they must give the rules that guide such sharing and such transference. And also they must inform you of your rights regarding personal data. You should be informed that you have the right to erasure, you have the right to rectification, you have the right to object to the processing of your data and any other rights that are applicable, the right to privacy as well. And also, in case the data controller or the data processor uses a data protection officer, they must give full information about the identity of the data protection officer in their website. So in case it is for registration or for employment processing in healthcare institution, such privacy notices should be included. And also it's required that the data subject acknowledges at the bottom of the previous notice that they are aware of all that is being required of them. And so currently there's mandatory requirement for any entities processing personal data in the health sector to register as either a data processor and also a data controller. So you're required to have a registration certificate, which is issued by the Office of the Data Protection Commissioner. So there's on the official website of the Office of the Data Protection Commissioner. If you look through it, there's a place where it provides for the registration as either a data processor or a data controller. And also there's a form that you are required to fill. The same is available on the first schedule of the data protection, registration of data controllers and data processors regulations of 2021. So you go to these regulations, you print out the form, you input that information, you log into the ODPC website, you decide, do I want to register as a data processor or as a data controller? And remember the difference between a data processor and a data controller, so that when you're registering, you know which to put. Am I being a processor or am I being the controller? So the certificate is valid for 2 years, but it can be varied. So if you meet the requirements that have been given out, then within 14 days from the receipt of that registration application and also the payment of the fees. The payment of the fees is also available in Schedule 2 of the same regulations. You can look the same up. on how much will be paid. And currently there are draft regulations regarding the processing of personal data. It is the data protection, conduct of compliance audit regulations. So these regulations, they give out the procedure for the conduct of audits by either the office of the DPC or any other person that or that wants to be accredited by the Office of the Data Protection Commissioner to be able to carry out data protection audits. And there's also the data sharing code. And this draft code, it gives for the requirements that data controllers and data processors should observe prior to carrying out the sharing of personal data, and the measures that they should put in place when sharing the same information to ensure that the same is protected, and also to whom it is being shared, that the same the confidentiality is upheld, and also the privacy of the personal data or the health data is applied. So there are offenses that can be committed by data controllers and data processors. And so this is failing to register according to the regulations. So for healthcare sector, it is mandatory registration. So failure to register. So if you have a health facility and you have not registered by the 31st of March, 2025, then you are conducting, and then that is an offense of which you might be penalized, of which you will be penalized for. And also it is an offense to provide false or misleading information for purposes of registration. Ensure you give accurate information. And also the failure to renew a certificate of registration and continue processing personal data after the expiry of the certificate, then that is considered an offense. As earlier stated, the registration certificate, the certificate is valid for a period of 2 years. So if this period lapses, then you have to renew the certificate. Failure to renew, it's either you stop acting as a data processor or a data controller, or you can continue, but the same you will be committing an offense which is punishable in law. And so the remedies that can be given for offenses conducted by data controllers and data processors, you can either be given an enforcement notice. This is a notice requiring you to rectify your mistake, or you can be fined. And so we look at case law. This one is a Kenyan case law, the NO versus Malibu Pharmacy. So as you can see, the name of the complainant is not given outright, because when you are filing a complaint under the Office of the Data Protection Commissioner, you also have the right to say, do I want the person that I'm complaining against to know who the complaint is from? And then again, here it is also to safeguard the privacy of this person, considering the issues that were in dispute. So the facts of this case were that a complainant filed a case against Malibu Pharmacy, alleging that her personal data, including her name, phone number, address, a wrong diagnosis, that all of these were exposed to outsiders outside the medical context. So she had ordered medicine, of which it came in a packaging. It contained her name, her address, her diagnosis, which she alleged to be wrong. And then the pharmacy was alleging that it had processed her personal information and health data in compliance with the data protection, because they were using it only for prescription processing, for delivery, for insurance reimbursement. But then they weren't able to provide sufficient evidence to support their claims. So the findings of the court were that Malibu violated the complainant's right to privacy, that they unlawfully processed sensitive health data by writing that on the delivery package. So this was a violation of her rights, because it was not necessary for them to exactly put her diagnosis on the packaging. So the same was held to be also in breach of principles such as data minimization and confidentiality. Because when they were sending the package, yes, her name was relevant for the transportation. Her phone number was necessary for her to be contacted when the delivery is made. Her address was necessary, but the putting of the diagnosis on the delivery, it was not necessary. Like, it was not necessary to identify this person. All they needed was the name, the address, and the phone number to reach this person. So the processing of this person's health data in that delivery was unnecessary. So the same was in contravention of the principle of data minimization. And there's also that it was held that, however, this health data was necessary when the same was sent to the insurance company because it was necessary for reimbursement. We had to provide details about this particular patient so that they can be reimbursed by the insurance. So the court's final decision, the pharmacy was ordered to pay the complainant 700,000 Kenya shillings for unlawfully processing her health data. They also issued with an enforcement notice requiring them to ensure compliance with the Data Protection Act. Next, we look at this case in the Court of Justice of the European Union. It was a reference from a German court to the CJU, requiring it to give a preliminary ruling. This patient asked his dentist to provide her with her medical records, as she wanted to use the same for liability in issues regarding his dental care. So the dentist demanded that this patient cover the costs with providing the copy of the medical records. And according to German law, when a patient requires a copy of their medical records, if it's for the first time, the copy should be given free of charge. But these people are requiring this patient to pay for it. So this patient moved to the German courts for them to determine whether the same was in compliance with his right to his personal data. The same was referred to the Court of Justice of the European Union where they said that the patient had the right to obtain the first copy of their medical record. So the healthcare provider, in this case, who was the data controller, they were required to provide a copy of the medical records free of charge at the request of this patient. However, on any other subsequent requests, it is only then that this patient would be required to pay for the provision of the medical records. So this patient had the right to a full copy of her medical records, her diagnosis, her examination, treatment details, so that they were able to understand the data and they were also using it for a liability claim. So we look at another case in the Belgian courts. So a Belgian hospital was fined 200,000 euros by the Belgian Data Protection Authority for breaches following a ransomware attack in the year 2021. So a hacker using Microsoft Office Exchange server, they checked for vulnerabilities, gained access to the hospital system, stole 5 GB of data, caused the emergency department to be shut down for 5 days. So when the Data Protection Authority investigated this occurrence, they revealed several violations of the General Data Protection Regulations, the GDPR, including failure by this Belgian hospital to conduct the data protection impact assessment. The hospital should have assessed the risks related to processing the sensitive data and things such as the staff emails. It also found that the hospital lacked effective security and privacy policy, and they lacked a formal integrated policy focused on security and privacy. And also they had ineffective IT security policies and practices. Their systems were inadequate. They also had vulnerabilities, so they were not able to handle such risks. And also their procedures were not up to date on how to deal with such breaches. They were also found to be lacking missing key security measures. This included insufficient employee training, failure to regularly test the security measures, weak passwords, enabling access to patient records. So the hospital was fined 200,000 euros. Initially, they had been filed 3 million euros, but considering the hospital's turnover, then the court reduced the amount to 200 euros. So this goes to show you the consequences that failure to comply with data protection can have. So in this case, if it were different court, they would have gone with the 3 million euros, and probably the health facility would have been required to close down for lack of resources, because when you pay out such a hefty amount of fine, then it may lead to the collapse of your business. So we look at the best practices for compliance. In the previous case, we have seen one of the issues that were raised was that the hospital lacked proper data protection impact assessments. So the healthcare facilities should have data protection impact assessments. So in this impact assessment, you can describe the process. You explain what data am I collecting, for what purpose am I collecting it for. Then you identify the risks. What could go wrong? Is it a physical record? Is it an electronic record? If it is a physical record, what's the worst that could happen? For the electronic records, what could go wrong about this? So for electronic records, then you're required to plan your fixes. What safeguards can you implement, both for the physical data and also for the electronic data? And then document. Keep a record to show your thought process and compliance. That's why it's necessary to have the privacy notices. So in such a case where you are sued that this person alleges, I did not give consent for my personal data to be used. So in a situation where you have the privacy notice, where at the bottom, it gives an acknowledgement saying, I have read, I have understood, and I have consented to the processing of my personal data. Such recording will shield you from legal suits and everything else that comes with the breaches of personal data. And also you should collaborate with other sectors, such as the IT sector, to ensure compliance, and also legal and compliance teams for robust oversight over the entire process. So if it's for IT, they will enable you to figure out the defects in the electronic systems. When it comes to legal compliance, it's about the policies, it's about the notices, what do you have in place to safeguard personal data, and just compliance with the law, that is. And also review regularly. Risks evolve, so you have to keep updating your data protection impact assessments to ensure they are up to date. So we always a step behind of technology. So if something new comes up, let's say your DPI did not have room for the use of AI, so you add that as a risk. You say, AI, what could go wrong with this? You plan a fix. What safeguard can I put in place? And then you record the safeguards that you're putting in place, your whole thought process, how you intend to ensure compliance, and then you use the correct tools for the same. And also you review the security protocols regularly to ensure that you comply. And also another best practice for compliance, you have to be at step with the changes in law, with the changes in regulations, because ignorance of the law is not defense. Let's say for this notice that was put up requiring healthcare providers who are data processors and data handlers, requiring them to be registered and issued certificate. It's already in April. You say, I have never seen such a notice. When then you're not excused from the law, because the same is required from you, that it is the law, it is out there in the public domain. You should know about it. And so with that, we come to the end of our session for today. We can go into, I can give over the mic to Njoki to proceed with the next part.
For that comprehensive presentation, I will ask anyone with a question to present it right now. You can put it on the chat. Yeah, we forgot to ask that if you have a question, you can just put it on the chat as we go by. Someone is asking whether there's a body that regulates the Data Protection Act.
Yes, there's a body mandated to regulate the Data Protection Act. That is the Office of the Data Protection Commissioner. In short, that is the ODPC. They have a website which you can visit. It is an office established by the Data Protection Act. And the commissioner for the Office of the Data Protection Act currently is Immaculate Kasait. So the Office of the Data Protection Commissioner, it deals with issues of compliance. It deals with issues of violation. It also, when you lodge a complaint, the Office of the Data Protection Commissioner has the duty to investigate into the complaint. They can also call the parties and since the parties are required to give information that may shed light to shed light on the complaint. And then after they have investigated, then the Data Protection Commissioner, it issues a determination, giving its reasoning, explaining issues that were raised, whether there was breach, and also it gives remedies, and it also enforces the same, and it also can transfer. You can also appeal a decision of the Data Protection Commissioner to the High Court. Yes, so there's a body that is regulating the same, and there were a lot of cases last year regarding issues of compliance, because currently most people have been trying to raise awareness on the issue of data protection. So the people are woke. People with complaints have approached the office of the ODPC with their complaints, and the same have been determined. So yes, the ODPC is the body that deals with regulation of data protection. Yes, I hope that answers your question.
Another question here is whether it's mandatory for medical institutions to have a DPO.
It is not mandatory for a healthcare facility to have a DPO. What is required is for any person that deals with the processing, you must have either a data processor or a data controller, of which now the data controller can now appoint a data protection officer, of which when you appoint a data protection officer, then you are required to notify the same to your patients, and also put the same on your website, informing them that we have selected a data protection officer whose details must be publicly available at the organization's website, and the same must also be shared with the data commissioner for transparency. So the duties of a data protection officer, it's mostly to advise the data controller or the data processor and their employees on data processing requirements provided Protection Act or any other written law that deals with the safeguarding of personal data. When also they appoint DPO, it is required that this DPO should ensure that on behalf of the data controller or the data processor, that the act is complied with. And also they must facilitate capacity building of the staff that is involved in the data processing operations, and also advise the data processors and data controllers on conduct of the data protection impact assessment.
And just to add, you can have, if you choose to have a data protection officer, you can either choose an external DPO, or you can appoint a member of the staff and give them the role of the DPO, as long as they are well trained. So allow me to read through the rest of the questions, Victoria, then you can answer them all together. The other question is, how well are healthcare workers aware and trained on data protection, considering that majority are on manual documentation? Another one is, with respect to data transfer between two geographical regions, e.g. two countries, is it a violation? For example, if I store patient's data on a server I own in the cloud, which is physically in another country, then what is your take on conflicting data protection standards on cross-border transfer of data? Finally, is there software that is offered to ensure that the privacy and security to be maintained?
Yes, we are together. There was the issue of whether health workers are available or they're trained in data protection. It's quite a recent field. That is why you are encouraged to collaborate with other sectors, such as the IT field, the legal field, so that you are able to be trained on the same. Because as we have said, it is not an excuse that you are not aware of the law, because you'll also be liable for breaches done by your own staff. As a data processor or a data controller, that's where the data protection officer comes in, because among his duties and responsibilities, it is capacity building. So in capacity building, it's mainly about training the staff and the workers about the protection of that personal data. And currently we are mostly moving away from the manual documentation, which is in books, because normally you go to a hospital, you go to the registration desk, they ask for your information, it's keyed in on the system, you go to the next part, this person on the other end has received the information, they tell you ABC and D, that when you send to the lab goes, when you get there, they already know what is required of you, because they're operating mostly through the systems. And for that, I think mostly the IT sector comes in, and also the legal sector comes in. And for also manual documentation, since it requires the same, then you're required to provide security to prevent unauthorized access of such data. For the next question was about the issue on conflicting data protection standards on cross-border transfer of data. I think for Africa, we are not yet there, because what was intended for us for the cross-border transfer was the Africa Continental Free Trade Area Agreement, and also the Malabo Convention, of which came into force last year, because very few countries have ratified the same. So currently in Africa, there might be barriers, but the continent is trying to rectify the same. I think the biggest step is the Africa Continental Free Trade Area, because it is supposed to facilitate both the transfer of data, the transfer of physical goods, the transfer of services. So we are hoping to get there eventually. But I can say for the European Union, they have done it, because for them, they moved away. Previously, they used to use a directive. So a directive is more of like what the Malabo Convention was trying to do. That if I put in a directive as a country, try compliance, like try as much as possible to adopt this what we have put in this directive into your own local laws. But then when the European Union came up with the General Data Protection Regulations of 2015, they moved away from this. When they call it a regulation, it means that it applies uniformly across all the countries of the European Union. So for the biggest bloc, the European Union currently, it's not the biggest. Okay, Africa is the biggest bloc, but for now, in case of facilitating cross-border transfer of data, the European Union is top-notch. They are very strict about their own compliance mechanisms. If you are someone who is interested in the same, you can visit the CJEU page. They put up all their decisions regarding everything. So in case you're interested in what are they saying about data protection in their own country, what are the issues arising in the European Union, the same is available on the website. For Britain, I'm not aware of much of it since Brexit in 2017. And yes, so I think for people who have succeeded in cross-border data transfer, we can look for guidance at the European Union because they have made quite remarkable steps on that field. Yes.
Someone asked concerning data transfer between two geographical regions. For example, two countries. Is it a violation if I store patient data on a server I own in the cloud, which is physically in another country? Yeah, like if I'm storing data I'm operating in Kenya, my institution is in Kenya, but I'm storing data in a cloud and the server is in Germany. So is that, first of all, is that considered as a cross-border data transfer? And would that be a violation?
So the DPA mostly requires that for this information to be stored to so long as the information you're collecting it's about Kenyan citizens or people within the Kenyan territory, then the Data Protection Act, all its provisions apply to you even if your server is in a whole other different state, because the same was collected here in Kenya and the same was processed here in Kenya. And the storage is the only different place of which you're required to put in safeguards. You're required to put in safeguards so as to enable the data to be stored securely. So also when you're doing the cross-border data transfer, you have to ensure that that receiving country where you're sending your data, that it also has security measures to accommodate the same. The standards in that other country must be similar to Kenya's, or alternatively, they must be higher than Kenya's own data protection standards. So, and also before you transfer this data, you must inform these data subjects that yes, I am collecting your data from here in Kenya, but the same is being stored in a server or in a physical location in that other different country. So when it is a transfer from one country to another, then the same, you must also require approval of the data commissioner, so that in case they want to impose additional requirements for you, like to ensure the safety and the confidentiality of the same data, that it is transferred to that other different part. So, and the same, it also requires regulation of cloud and everything else that has to do with the digital.
Okay, I see more questions here. Thank you for answering that. But that would be an interesting also area to explore on the issue of cloud storage, because I don't think it's comprehensively covered within the regulatory framework. It has not been exhausted, because I would think most of most people actually store their data who use cloud storage. The server is not in the country, even including Google. So if I'm storing my stuff on a Google folder, that's on the Google Cloud, Dropbox, all those have their servers out there. So it's just a subject that we will consider exploring. And then there's another question: what is there any software that is offered to ensure that privacy and security is maintained? Then we'll read this one. It's a situation someone has presented here, that a patient was admitted to a teaching and referral hospital. A doctor accompanied by medical students came to review the elderly patient who felt exposed and uncomfortable. The patient lodged a complaint to the hospital, but was informed that the facility is a teaching and referral institution. Was there a violation of privacy?
So
All right.
for the first question regarding software that is offered to ensure privacy and security is maintained, for that, people make their own things tailored to their own problems, to their own solutions. So when you are doing your own data protection impact assessment, it will tell you exactly for the software that you're looking for, what exactly should you have. That's why we were saying for best compliance, you have to partner with other people. I don't think there is a software just there on the internet waiting just to be explored for privacy and security measures. I think that is where the IT comes in, the issue of cybersecurity, which is for the IT sector. That's where they come in with regard to ensuring privacy and security. It's not a one shoe fits all kind of thing. When you do your own data impact assessment, you will determine what safeguards should I use, because based on what you are doing, based on the information you are processing, and based on how you are collecting it, how you are storing it, how often you use it, who have access to the same. When it comes to that, that we leave it to the IT guys. I think you can do cybersecurity experts, get options, get opinions, and then decide on what works best for you. I hope that question is answered. And then the other question, it was about a patient admitted to a teaching and referral hospital. So among the rights of the patient, you have the right to object to the processing of your personal data. And I think for students, most of the time they are usually required to obtain, before you treat a patient, you are required to obtain their consent regarding their autonomy, regarding their consent. We talked about the medical consent. We also talked about the data protection. So in this one, it's more of medical consent, because it is more about the physical person of, like, it's about their bodies, and of which it is what that made them uncomfortable. That falls on the side of medical consent. I think that's also another area to explore. But based on what we have at the moment, you do have the right to object. I'm not fully aware of the whole scope of the issue to do with students, because I know the issue of research. So for that, I think it's probably also an area to explore on the issues of privacy, because I should mention that there is privacy. Privacy is an umbrella. Data protection is part of it. Like, most of data protection falls under the umbrella of privacy. But then privacy is much bigger than data protection, because some things that are in the scope of privacy don't necessarily fall under data protection. So for that, it will be a whole discussion on whether it is it privacy on itself, or is it under, or the same under data protection. For some jurisdictions, they have a clear-cut line: what is privacy, what is data protection. That you'll find in the GDPR, because they have a whole article on the right to privacy. And the right to data protection it's a standalone right that even without the umbrella of privacy, data protection will still stand. So yeah, we can explore on the issue of privacy vis-a-vis data protection. What protection does privacy offer that data protection does not offer, and also what data protection offers that privacy does not offer. So yeah. And with that, if there are, I can take any more questions if there are any. Okay, all right, I'll assume we have no more questions for this session.